Hello, everyone. Hope you're doing well. Welcome to this week's Material Chapter 9 Law and Ethics of Patient Confidentiality. So, we talk about confidentiality quite often, right, from the perspective of HIPAA. And I know that HIPAA is ingrained in your mind if you worked in a healthcare organization because of the complexity that electronic health information and protected health information has. And it's, I think, a great thing for us to study in this chapter because we get to really think about, hey, what does HIPAA do? What does it protect us from? What rules are associated with HIPAA? And we're going to talk about that here in the near future. HIPAA privacy rule, HIPAA security rule, all those are important elements of this part of our communication. So, when we talk about patient confidentiality, privacy, and privileged communication, matters tied to these instances are both legal and ethical concerns. So there is a legal concern if, of course, you break privacy or privileged communication laws, and there's an ethical concern if you do as well, because in turn you're not doing what's best for the patient. So, delivering information that shouldn't be delivered based on maybe just gossip or something to be involved in is critical in a negative way, especially from an ethical and legal perspective. I'll give you an example. In a healthcare organization that I worked in the past, we've had several members of the Hollywood community come in to get serviced for treatment of some type or another. And it could be primary care, it could be, maybe they were coming in for OB care, it could have been, mental health, anything. But we've had instances where some of our, not just providers, but also our employees had said something to someone else about, hey, I saw this celebrity, and to be seen, at this such and such provider. That is a breach of confidentiality. That is a breach of privileged communication. And of course, will result in termination the majority of the time, depending on how, of course, the information got out. And I've had to do that numerous times myself in relation to holding people accountable. I've had to fire people for HIPAA breaches, and that is not abnormal. So make sure you take this very seriously. We're in healthcare to help each other, to help patients. We're not in healthcare to gossip, and that's the majority of what I want to convey to you today. It's very important. So privacy. Privacy was enacted back in 1973. Roe v. Wade was not just some of the elements that we've talked about in society today. And I know there's a lot of debate about that, but it also has to do with constitutional rights of privacy. So, privacy was an element of that, and that's what I want you to take from this information here, even though there's a lot more we could expound on in regards to that Supreme Court decision. However, in healthcare, this privacy right is also the right to be left alone. So patients do have the right to say, hey, I don't want treatment, and that is okay. That is, of course, if they're cognate, right? Maybe someone has a do not resuscitate lanyard on. That, of course, is their right to say, hey, I don't want to be resuscitated, I want to be left alone, and that's a patient's right to choose that. Moving on to confidentiality really quickly. We've talked about our EMR, EHR module. We talked about protected health information, right? That's EPHI, electronic protected health information, but protected health information is an element of confidentiality that we've talked about. I gave you an example of patient-provider relationship. That is a sacred bond between the patient and their practice, and that should not leave the element of care based on communication. So, yeah, if you're a front desk person, you're checking on a patient, of course you can have an awareness of who's there at that time. However, that information should not be conveyed to people that are outside the medical sphere of care for that patient. And I'm not saying that it's okay for the PSR or front desk person to go down to general surgery after checking in a primary care patient and say, hey, do you know who's in the building today? That is still a breach of confidentiality because that has nothing to do with the patient's care at that given time. All right, here's a quick knowledge check question. A high priority concern for everyone who has contact with patients and their PHIs to maintain what? Think about that a little bit. Of course, it's confidentiality. Maintaining confidentiality is a high priority for everyone who has contact with patients. All right, we're moving on. Privileged communication. So communication that is privileged between two people or a group of people. We've seen this a lot in email exchanges potentially, or maybe legal exchanges, right? Attorney-client privilege. I'm sure you've heard of that before. But it's the ability to be open and honest with your provider in order to feel comfortable that your information won't be conveyed in a way that is negative and a detriment to you. Maybe you're talking to your provider about a situation that you've had in the past where you were treated with, disrespect, and it's caused you some emotional burden. You want to feel that when you display that privileged communication to the provider, that it's not going to come out and not be told to someone else that shouldn't be involved in your care. That's just an example. HIPAA, we're going to jump into this. HIPAA is a huge, huge thing from the perspective of the law that it created. So it's federal privacy protection, and it's a threshold for protected health information, including electronic protected health information, which we talk about in the third bullet here. But before HIPAA was enacted in 1996, the start of its enforcement started kind of in 2003. There was no federal law governing individuals' healthcare information. However, I want to point out that that doesn't mean that providers are out there talking about their patients all the time. However, it wasn't enforced. So, a patient in that period of time prior to 1996 could have sued a provider for maybe giving information they shouldn't have put out there, but there was no federal law attached to it, and this helped concrete that start. And we've talked about EPHI. Electronic protected health information transitioned once we moved into the high-tech version of electronic health records. So when we moved into that, that's when EPHI started coming up as an important solution to correspond with HIPAA. Two rules in HIPAA, one being the privacy rule. It was enacted in 2002, and it ensures protected health information is protected while also permitting sharing health information to improve healthcare quality. So let me give you an example. Say a patient comes to the ED in, I'll say Olympia because I'm located in Olympia, Washington. Come to the ED in Olympia, Washington, and they're seen for an issue, and they don't know exactly why they're seen. Maybe they had something where they weren't cognitive. Maybe they passed out because of an injury. They were treated, all right? Another injury happens the next day. They're still not cognizant of what happened. They go to a different ED. If that ED shares the same electronic health record system, they'll be able to hopefully, if there's the same instance, they'll be able to hopefully see what the other treatment was, so they're not duplicating treatment or doing something unnecessary that the patient has already had done. Maybe they're on antibiotics that they don't need to overprescribe, or maybe they've had a controlled substances to help with pain that they don't want to prescribe again to the patient to make sure there's no abuse. There's a lot of examples of this from a privacy rule perspective, and it protects the patient because we're not delivering healthcare that they don't need at that time. The security rule is a little bit different. It protects PHI that's stored or disclosed electronically. So it expands on the privacy rule and protects and addresses safeguards that covered entities must have in order to secure electronic protected health information. So its covered entities are required to establish administrative, physical, and technical safeguards to review security risk and compliance of this rule. So let me give you an example. If you have an electronic health record system, let's say Epic, they are required to have security protocols to make sure that their information is not accessible. So from the starting point of, hey, let's look at my information being stored on the cloud for the electronic health record, and I know everyone nowadays is aware of what the cloud is, right? It's not stored on your computer per se, it's stored in the internet, in a sphere somewhere in the cloud. They have to actually have security verification purposes for protecting that information. So the security rule says, hey, Epic, hey, healthcare organization, you have to make sure that people don't have access to this when they don't need it. And that's what that talks about. HIPAA compliance is a big time need, right? You do have surveyors that will come in and will, of course, if they find anything from the perspective of maybe they're a CMS surveyor, Centers for Medicare and Medicaid, and they come in and they say, hey, you're not being HIPAA compliant, they will do a survey and they can fine you or maybe even potentially shut down your practice if you have issues that continue to come up or if you have a HIPAA breach, and that happens quite often. when you have a HIPAA breach is what I'm saying. It happens quite often that you're held accountable. The enforcement rule allows the Health and Human Services to investigate complaints that are covered entities have violated from the privacy rule or the security rule perspective, and they are authorized to request the Department of Justice to bring criminal charges when the circumstances warrant. So I talked about that. If there's serious harm to a patient, there can be criminal charges if you break HIPAA violations. Breach notification rule requires that covered entities and their business associates provide notice of a breach when information or issues happen. So that's saying, hey, if I have a breach in my healthcare system, I'm going to let the government know and let the feds know that I have an issue, and I'm doing the steps needed to take care of that breach. And that's what they want to see. Going to move from the knowledge check here. You can take a look at that on your own time. There are some exceptions to the breach rule. I'm not going to really go over these, but maybe an unintentional acquisition, access, or use, inadvertent disclosure of protected health information by a person authorized to access it, or a covered entity or business associates have good faith belief and does something but doesn't do it on purpose. It's not a high form of negligence. You can take a look at these, and there are times where the feds will work with you to make sure you have corrective action instead of really fining your facility. All right, there are some penalties to be aware of. 4 tiers of HIPAA penalties, and they're located here. So $100 per violation is tier 1. Covered entity was unaware that it happened. Tier 2 would be covered entity was aware but could not avoid it. It's a minimum fine of $1,000 or up to $50,000. Tier 3, direct result of willful neglect. So you had major negligence and you didn't do what you were supposed to do to protect patients. You can be fined up to $50,000. And then Tier 4, no attempt to correct the issue, minimum fine of $50,000 per violation. This does not include the potential for shutting down your facility if they feel like that is an element of what's needed. And I'm talking on the federal level there. So anyone who has reason to believe the covered entity or associate may file an OCR. An OCR is filing a complaint on the HIPAA side, and you can do that actually online, and there's plenty of ways and methods to do it. You actually can Google OCR and come up with ways to file a complaint. Video really quickly. The Office of Civil Rights is what we're referring to when we talk about OCR. And I'm sorry the screen is a little bit to the side here, but this means that you can go through the HIPAA privacy and security rule and do a violation complaint. And it is looked at. So the feds will look at this and they take it very seriously. So that's an element that I think you should be aware of. I'm going to move this back to where it's supposed to be here. So you are able to file a complaint. Patients can file a complaint. Anyone can. So there's some challenges, of course, we've already talked about to maintaining effective confidentiality, one being technology, and then high-profile patients, right? These celebrities that we've talked about coming in. Information gets out. We, as healthcare providers, need to make sure that we do our due diligence to make sure that people are held to a standard and it's not discussed on our end. Like if there's media standing outside when a high celebrity person walks in the door, we're not allowed to permit them into our facility potentially, but they can be outside. They might be aware that care is being received. However, it is up to us to make sure that we don't display that information or convey it in a way that breaks HIPAA. All right, we're going to move on from the knowledge check. Unauthorized or authorized PHI uses and disclosure. This is a really interesting case of the University of California that makes clear that in some circumstances there are interests that outweigh a patient's right of confidentiality, and HIPAA recognizes this. So one of it could be mental health provider maybe doesn't want to convey information about a circumstance to a patient because it might negatively impact them in a negative way, potentially for their future. That's just one example. But there are times where HIPAA can be disclosed if it's necessary to protect the patient. And we won't go into a lot of detail about that, but there are methods to this and there are reasons. All right, we're going to kind of bypass this, but you can read through patient authorized PHI use. Some information here that I think is interesting. Last thing I want to talk about is confidentiality is an ethical dilemma. It is an ethical dilemma, especially from the perspective of making sure that we do our due diligence to make sure people are safe. So making sure that we convey things that need to be conveyed. Flu vaccines, things like that are often things that are conveyed to the government from their perspective so they can have relevant data to protect us all. That's all for this lecture. If you need anything, don't hesitate to reach out. More information to come.